Well, greetings, everyone. We're joining you once again from HBL headquarters in Atlanta, Georgia. And today I'm joined by a very special guest, Ann Tyler Hall, our principal attorney. Ann Tyler, hello, how are you?
Doing well. How are you?
Doing great. Thank you. We are here to discuss for our monthly ERISA update an article that you wrote and co-authored with Eric Schillinger at the end of about a topic that was hot and heavy at the end of 2020, but impacts employers throughout this year and will continue to impact employers. And that is on the topic of partial plan termination and the impacts on partial plan termination from the Consolidated Appropriations Act, which was passed towards the end of 2020. And so we're going to link our viewers to that article, Ann Tyler, in the text below our video. But we wanted to give people a little bit of an inside view of the article from the author herself, and hopefully break this into some easy to understand terms for folks. So I've got 3 questions today. The first of which is simply for employers out there, for plan providers, for folks out there who may not know, could you just give us an idea of what is a partial plan termination?
Great. So thank you, David. So firstly, when we're talking about partial plan terminations, we're talking about tax qualified retirement plans that this pertains to. And it's really important for retirement plans that have vesting schedules, because if a partial plan termination is deemed to have occurred, then you must immediately, as the plan sponsor, vest the participants in the plan 100%, vest affected participants 100% in their for instance, matching contribution or employer contribution account. Obviously, always the elective deferrals are 100% vested, but we're talking about vesting matching contributions. And for some employers with a 3 or a 5 or 6 year vesting schedule, 100% vesting of the employer contribution plus earnings can be significant. And so it can be a significant event and with significant implications for plan sponsors. And so a partial plan termination is defined by IRS guidance and tax rules as generally a reduction of more than 20% in the number of plan participants during a plan year. And so this is calculated, this 20% reduction is calculated by looking at the turnover rate. And the turnover rate is determined by dividing the number of participating employees that experienced an employer-initiated termination of employment, so not employee-initiated. And companies can use and should use careful documentation to show who was initiated termination voluntarily by the employee and who was terminated due to, for instance, a business downturn or a downturn in business for a company. But the turnover rate looks at those who've experienced an employer-initiated termination of employment during an applicable period by the total number of participants. And employers, in determining that turnover rate, can also add in to the denominator, to the total number of participants, any additional new hires made during the time period that's being evaluated as to whether a partial plan termination occurred. So the turnover rate, the numerator is those individuals, those participants who were terminated, and that termination was initiated by the employer, divided by the total number of participants during the applicable time period being reviewed, plus any new hires during that time period.
Okay, I apologize for myself, for other folks out there who may not be retirement plan professionals. Can you just explain a little bit more about the fact that the plan is partially terminated? Does the plan continue for participants still in the plan? There's still a plan. It's just that a portion of the plan has been disqualified. Is that an accurate statement?
No, it just means that for those affected participants, when a partial termination has occurred or is deemed to have occurred, or the employer through work with legal counsel determines that it's best from a risk perspective to assume that a partial plan termination has occurred, that those individuals affected by that termination, partial plan termination, so those employer-initiated terminations, those affected participants would be 100% vested in their.
And so the remaining participants just continue the plan as before.
That's correct.
Okay,
That's
great.
right.
I think that's a really maybe a little bit of a nuanced piece there, and I think that's something our audience needs to understand, that the participants who remain in the plan as before. It's only the termed participants who receive the full vesting, and that's the piece that's a partial termination.
Right.
Great. Okay. So that's obviously an event that's linked to employee loss or employee turnover. Relative to COVID, employers have lost a lot of employees in some sectors of the economy. Tell us a little bit about the relief that the Consolidated Appropriations Act that was passed at the end of 2020 offers employers as a follow-up to part one of our series here, or our questions here, talking about what is a partial plan termination. Now tell us, what is the relief that's offered from that scenario in the Act?
Right. So pursuant to the Consolidated Appropriations Act 2021, which was passed and signed into law on December 27th, 2020, what this relief provides for is from the period March 13th, 2020 through March 31st, 2021, i.e. the relief period. This is about a 1-year window. If the number of active participants covered by the plan is at least 80% of the number of plan participants covered by the plan at the beginning of the relief period, i.e. March 13th, 2020, then a partial plan termination, there's relief from a partial plan termination being deemed to have occurred. And so some nice relief, particularly for employers who may have had to lay off, for instance, employees during a COVID-19, during a work from home, or during the COVID-19 pandemic, for instance, a restaurant that had to lay off due to restrictions around opening the restaurant, had to lay off, for instance, a significant portion of their workforce, but then was able to bring them back, for instance, in the fall or in the past few months, as long as they do that before March 31st, 2021. And they are back up to at least 80% of the number of plan participants as of March 13th, 2020, last year, then a partial plan termination has not occurred. The relief provides that there's a relief period from the partial plan termination rules.
Okay, so I can see how that would save the employer a lot of money, because they're not having to then vest those participants that they let go, but then they've brought back. And so those participants are essentially put back on the same track as the other employees that were not termed.
That's
so
right.
For our listeners today, for our audience, there's a lot of numbers and a lot of moving parts to this. And so again, I would encourage you to reference the article itself, which we will link in the either the comments below the video or in the video itself. So please be looking for those. And as we wrap up our time together today, Ann Tyler, I want to close by asking about action items. What are some things that employers should be looking to do, or things that they can be doing to take action to take advantage of the relief that we're seeing in this bill?
Okay, I'll get to action items. Those are great. That's a great question. I'd first like to say that with respect to this temporary relief, when you're looking at that 80% threshold and over a 1-year period, whether you're back to at least 80% of your workforce by March 31st, 2021, as compared to what you had on March 13th, 2020. And specifically, we're looking at plan participants, not just your workforce, but plan participants. You do not have to rehire the same individuals that you let go in order to avoid a partial plan termination. So I just want to make that distinction. With respect to some action items for plan sponsors, it's a good idea. It's just a good best practice anyway to be looking at your plan document, reviewing the plan terms and conditions related to partial plan terminations and related vesting considerations. And if you are close to or above the 20% year-over-year plan participant turnover rate, and you wish to avail yourself of these partial plan termination relief rules, you may want to, at this point, consider recruitment and hiring if you haven't already done so. So if you're an employer that, for instance, you had in March 13th, as of March 13th, 2020, you had 200 plan participants. And during 2020, you had to terminate due to a downturn or due to COVID-19 circumstances. You had to terminate 50 of those employees. If in 2021, before March 31st, 2021, you hire back, or you don't have to hire back the same employees that you've let go, but you hire an additional 10 plan participants, employees that are eligible to participate in the plan by March 31st, 2021, then you will have avoided or you would be able and eligible to avail yourself as a company of the partial plan termination rules. So it's important to review your plan document terms on what is a partial plan termination, what are the contours of a partial plan termination subject to your plan document, and looking at if you're close to that 20%, more than 20% employer terminated threshold, then what can you do between now and March 31st to maybe add additional employees, add additional plan participants? And then the caveat is, if you hire employees, new employees, so this example that I alluded to earlier, if you hired 10 new employees, but they aren't eligible to participate in the plan until after March 31st, 2021, then they would not count towards the denominator in this partial plan termination turnover rate analysis. So the other important item is you need to look at your eligibility rules and potentially consider immediate eligibility into your, for example, 401k plan. If you're looking to avoid a partial plan termination, looking to add new employees, new plan participants to avoid a partial plan termination. So those are some best practices, looking at your plan document, considering adding new employees and making them immediately eligible.
So those are all things certainly the HBL team can help employers with. If an employer is trying to take advantage of this, we know as a basic sort of seminal baseline issue that employers are fiduciaries just by nature or by definition of the retirement plan itself. Who should they be leaning on? Is it the record keeper? Is it the TPA? Is it their ERISA attorney when they go to make sure that these things are done correctly?
We've been involved in several partial plan termination analyses over the past year with the flux in workforce due to COVID-19, and some of the determinations as to whether the terminations were employer initiated can be complex and nuanced. And so it's good to have counsel to memorialize the facts and circumstances, to make a defensible argument to the IRS that a partial plan termination has not occurred, particularly for companies that want to make the case that a partial plan termination has not occurred. It's very important to have ERISA counsel looking at the terminations and the facts and circumstances, looking at the applicable period in which the terminations occurred, and preparing documents and memorializing that review, so that if the IRS came in and audited this, or a participant complained, you have a defensible position. That's why it's so important to have ERISA counsel in this process. But you mentioned other service providers that are important, but I think the initial analysis necessitates generally a ERISA counsel if there's any gray area or any doubt about whether
certainly for an employer of a size, right? I mean, if you've got 10 employees, the calculation is fairly easy. If you have 10,000 employees, it becomes much more complicated. And I think that's where, obviously ERISA counsel would be a necessity, not a recommendation.
Absolutely.
Where is there a threshold at which you think maybe, an employer could say, okay, I've got X number of employees. I did lay people off. I do need to take advantage of this, this relief. What size should an organization be thinking about seeking counsel?
I think once you hit the 100 employee, 100 plan participant mark, it becomes more important, just because you're probably looking at more dollars and more implication to the employer with respect to a 100% vesting, an immediate 100% vesting.
Unless I'm mistaken, that's also the audit threshold, correct? So if you have that number of employees or more, obviously you're in a higher risk category in terms of,
right.
of agency scrutiny.
That's right.
Okay.
That's right.
Good. Well, do you have any final thoughts on the article? And Tyler, you and Eric did a great job putting it together, and LexisNexis picked it up, which was great. We got lots of eyeballs on it. It's always good to revisit these articles, flesh them out a little bit. If you have any final thoughts or suggestions for our audience, we'd welcome them.
Absolutely. So just a closing note on these partial plan termination rules. It's going to be interesting. Our commentary from HBL is that this applicable period of relief may be extended because we're still in the midst of COVID-19. We're certainly not out of this COVID-19 pandemic, and businesses are still experiencing the repercussions of shutdowns and COVID-19 related situations that significantly impacted businesses. So it's going to be interesting, and we'll keep a close watch on this, and of course write an article and talk about it. But it'll be interesting. I think we may see legislation extending that time period beyond March 31st. So be on the lookout for articles from us if that happens. But for plan sponsors, for employers who may be on that edge, teetering around, having to have laid off in 2020 more than 20% of their workforce, this is the time to be thinking about adding new eligible participants to your plan. There's only a few more weeks left, and making them immediately eligible to avoid what could be a significant cost to an employer, an unexpected cost to an employer. So this is the time to be thinking about it. Again, we just got it a little over 2 weeks to add into the denominator on the turnover rate for the partial plan termination analysis, new plan participants.
For our audience, we're recording this on March 15th. So when Ann Tyler references that 2-week window, you've got a couple weeks left until the end of the month. If you have any questions about partial plan terminations, if you have any questions about the legislation itself and how it impacts your business beyond beyond partial plan termination, please reach out to us. Again, our contact information will be in the text below the video or embedded in the video. Please reach out to me directly. I can connect you with an attorney on our team. Ann Tyler, it's always such a pleasure to be with you, and we appreciate you sharing your knowledge with our audience today.
My pleasure.